Hi, this is Curt, and welcome to another edition of Fire Law Roundup. Well, that brings us to our last case for the week, and that's the Denver case. And this is sort of a companion case to a case that we had talked about in the past. It was basically Charmaine Cassie and Delasha Allen both had filed race and gender discrimination claims against the Denver Fire Department. Both ended up being terminated. The cases are factually different. They were filed together. Allen's case was decided last September, and I haven't seen any appeals on that. I'm not sure what the status of that would be, but the court pretty much, said that there was no possibility of race discrimination, that no reasonable jury could attribute what happened to her race or gender. So, excuse me, that was the Allen part of this case. Cassie was a little bit different. And again, this kind of ties in with what we were just talking about the Washington State case. Cassie was put in the first academy, was it's called Academy 2018-02. Okay, so this was the second academy that they held in 2018. And about 14 weeks into the academy, she hurt her shoulder, and then she was washed out of the academy, but she was given a position in the next academy. That academy, she ended up hurting her shoulder again, as I understand it. But she wanted to go into the following academy, which would have been 2019-02, but that was a lateral hire academy. And I'm not sure how many weeks it was, but because she wasn't a lateral hire, she wasn't already firefighter 1 and firefighter 2. I think she might have been firefighter 1. They said, you really have to be firefighter 2 to get into the lateral hire. She was not happy about that. She felt like she should have been allowed into the firefighter 2 academy. So that was one of her allegations of discrimination, that she wasn't allowed into that academy. But the bottom line is she's allowed into 2019-03. Okay, so she gets into the third academy in 2019. And toward the end of that, this ended up wrapping up right around the end of 2019 and into 2020. She injured her knee. Now, she was able to finish the academy, but she also became pregnant. So she couldn't complete her on-the-job probationary period, which required her to work in 4 different stations. And, she was graded on that. That's actually where Allen had her bigger problems. She had problems in the academy, but she had problems on the probationary period as well, and she was washed out there. So Cassie completed the academy, but did not complete her ride-along time, her probationary ride-along time. And because she was pregnant then, once her knee was all set, she had time off due to pregnancy, and then she had a back problem that she doesn't allege had anything to do with work, but she had a back problem. And the department accommodated her, apparently, up until October of 2021. So in other words, she was on the payroll of the department from 2018 all the way to 2021. I'm assuming still as a probationary firefighter, because she hadn't gotten off probation, because she hadn't completed the tours on the apparatus. And she alleges that it was because of her race and gender that she was being discriminated against, and that also she had filed a lawsuit in 2020 with Allen, and she was terminated in 2021. So now we're in a situation like we just talked about with the Washington case, where she files a lawsuit, and then a year later, or in Washington it was months later, but in this case, she files a lawsuit in 2020, and 2021 she's terminated. And she's saying, oh, that's retaliation. And the court, court went through all of the allegations, went through your favorite test here, the McDonnell-Douglas test. And I mentioned this to you the other day. It almost seems like different courts interpret McDonnell-Douglas differently, but essentially, and you can read the case, you can read the quotes that I have from the case there. But essentially, the fire department had a legitimate reason for letting her go, that she was, she was not able to do the job. And how long can we continue to pay someone? It's 3 years, 4 years, 5 years. I mean, what's 2018, 3 years? She was getting paid, and she hadn't really even worked on a fire truck yet. And she was apparently offered 29 different positions with the city. So it wasn't like they said, look, you're either a firefighter or you're nothing. Here's 29 jobs, and she didn't express an interest in any of them. So, and again, you can read here basically the department had a legitimate reason to terminate her employment, and again, you can read the quotes, but
look, it is a hard discussion. I know, because I have this all the time. I've had it recently. It is a hard discussion with your client to say, listen, I agree with you. You have a completely non-retaliatory, independent reason to terminate this person. But the fact is, he, she, they have already alleged some sort of discrimination, and you already have maybe an ongoing investigation, right? And the comment I always have is, listen, you're buying a lawsuit. But if you the lawsuit's coming, you're not going to prevent it, except maybe with a really good letter and the hope that they find an honest lawyer, all right? But we always know there's always some lawyers willing to sue. And so you're buying a lawsuit. On the other hand, my follow-up to that is, but you can't be afraid of it, because if you allow yourself to be abused this one time, when you have a true, legitimate, independent, substantial reason to fire someone, if you just cave in to, oh, you're discriminating against me, everybody's going to say that. I told you about a conversation I recently had with someone, and I'm saying, well, why do you think you're terminated? And they gave a reason. I said, there's nothing wrong with that reason. They're like, well, I want to be able to sue. I'm like, well, and so I said to the person, I said, do you think you're being discriminated against? You have some reason you believe they got rid of you other than they just didn't like you? And he's like, oh, would that matter? Like, wait a minute, let's not make one up. If you have one, that's one thing, but don't make it up. If people have the right to terminate you, and if you give them a legitimate reason, they're going to do it. But I don't think employers should be scared. Look, you were buying a lawsuit, there's no question, but otherwise every employee is going to treat you that way, and you'll never terminate anyone, and you'll have a cesspool of some employees who should have been terminated, right? Just because they threatened you. So I get it as an employer. Nobody wants to be sued, but guess what? Right? It's the nature of our business, unfortunately.
Yeah. Well, one of the things I neglected to mention, she alleged race discrimination, gender discrimination. The court spent a lot of time talking about her disability discrimination claim, because she claimed that she had a disability. She sought a reasonable accommodation, which would have been another 7 months or so of unpaid leave. But there was no evidence that at the end of that 7 months that she actually would have been able to come back. She couldn't produce any sort of medical documentation that if she had the 7 months, all she did was she asked for 7 months, but she had no doctor's documentation that she would have been able to come back. And again, I'll read from the decision here. The plaintiff's accommodation request for 7 months of continuous unpaid leave is undisputed. That is not a plausible, reasonable accommodation. An employer does not have to retain a disabled employee on unpaid leave indefinitely or for an excessive time. Therefore, any request for a lengthy accommodation is unreasonable. Plaintiff has not presented evidence that she was otherwise qualified at the time of the alleged discriminatory activity. Therefore, defendant's motion for summary judgment is granted as to the ADA claim. So, again, a lot of moving parts in this one, but I really, hats off again to Denver and Denver Fire Department in terms of the way that they were able to handle this case. And, not to, certainly firefighter Cassie and also firefighter Allen, who had, been terminated previously, people can, they can experience things differently. You know, everybody experiences things differently. You and I, we talk about the Red Sox and the Yankees, and you and I sitting together at Fenway Park, we're going to experience close plays differently. So it's not to say that
this year's Yankees, we're not experiencing anything close play.
This is, yeah. Even though the Red Sox are not doing well, at least they're doing well against the Yankees. So, but it's a good year, I guess you'd say, for the Red Sox. But the bottom line is, people experience things differently. So it's not to say that these folks didn't honestly experience it in a certain way, that they were the victims of discrimination. But from the department's perspective, the department documented their reasons, both in the Allen case and in the Cassie case. And again, hats off. It's almost like a model for how fire departments should be documenting their employment decisions when it comes to these types of cases.
Right. And look, you know, I find, we're going back to the physical issue, I find that many departments that I'm doing policies for do not have a policy that says you cannot stay on disability for X whatever. And even the volunteer departments are worse. The volunteer departments, a lot of them have a medical leave in their bylaws, and we could talk about, we're going to do a bylaw issue, right? A bylaw conference coming up. But one of the major bylaw issues is leaves. And if you don't state you may only be granted 6 months of leave at a time and no more than 24 months total or whatever, then somebody may legitimately claim, I've got a lifetime to come back. You can't get rid of me. So as we'll talk on the bylaw issues, leaves of absence or disability as an employer, you should have a policy that says you've got X days, weeks, months, and this is probably going to be a mandatory topic or subject of negotiation, right, with union. But after X time, if you can't come back, let's fill the position. And I think unions would be in favor of that after a reasonable amount of time.
Yeah. And one of the questions becomes, what's a reasonable amount of time? I had a client that she had a shoulder injury, and her doctor, and at the time, this department had a hard and fast 18-month rule. But she hurt her shoulder, so her doctor recommended rehab. So she did that for 6 months, and they said, now we've got to do surgery. So then she had the surgery, another 6 months of rehab after that. And then the doctor said, and now we're actually over a year. We're up to like 14, 15 months. And he says, I got to go back in. And so, you know, now you're putting somebody in a position where you come back and you're not 100%, knowing you're going to hurt it again. Right. Or do you get it fixed? And, you know, the hard and fast things, I think that, I don't know, there's got to be some sort of a reasonable basis, and, you know, for stretching it out. And in this case, I think there would have been, but unfortunately, she was forced to retire. She ended up going for the other surgery and unfortunately forced to retire. So,
yeah.